Well, I'd like to welcome everybody to the sixth in our series of regular arbitration breakfast briefings, which we've been conducting during the course of this year. We hope you find today's talk instructive, and this is going to be the last briefing before the summer break, and we hope to resume in October. Good morning to our friends and colleagues in the UK and elsewhere in Europe. Good afternoon to those of you joining from the UAE, Africa and Mauritius, and good evening to those of you in Singapore and elsewhere in the Asia Pacific region. With me today are my colleagues Alan Gourgey QC and Tom Robinson, who form part of the arbitration team at Wilberforce Chambers. And in today's briefing, as you know, we're going to discuss the concepts of arbitrability, admissibility and jurisdiction in international commercial arbitration. We're very keen, as always, that today should be an exchange of views. We welcome your contributions. Please use the Q&A button at the bottom of your screens rather than the chat button to ask questions throughout the session. We're very happy to try and deal with any questions as we go along, so feel free not to wait until the end of the discussion if you want to raise any questions. Finally, for light entertainment, we have today 4 polls during the course of the discussion, from which we're interested to get your own instinctive views on the questions asked. Now, to outline today's webinar, we're going to start by seeking to define the concepts that we're dealing with. We're then going to look at the recent English Commercial Court decision in Republic of Sierra Leone and SL Mining, and some FIDIC arbitral awards where the approach in Sierra Leone has not been adopted. We're then going to look at the position in Singapore and in Hong Kong, then ask, in the light of the case law, why the distinctions between the concepts matter. And finally, we're going to touch on the Commercial Court's decision in Armada Shipping and Schiste Oil and Gas, which Tom is going to be talking to us about. So let's begin by considering what is meant by each of the concepts of arbitrability, admissibility and jurisdiction. Understanding the concepts is a bit like playing three-dimensional chess, because first of all, the distinctions between the 3 concepts are not always clear. Second, the distinctions drawn are not always the same across different common law jurisdictions. And third, the concepts have been used in different ways over time. We want to look first at arbitrability and jurisdiction. At least so far as English law is concerned, arbitrability is perhaps the easiest of the 3 concepts to define. The New York Convention provides for the recognition of an international arbitration agreement which concerns, quotes, a subject matter capable of settlement by arbitration, close quotes. And the UNCITRAL model law is similarly limited to disputes that are capable of settlement by arbitration. And we suggest that this is what is meant by and should be understood as a dispute which is arbitrable. But even with the concept of arbitrability, there are difficulties. US case law frequently conflates arbitrability issues with jurisdiction issues, and there's considerable scope for debate as to what issues may or may not be arbitrable. Matters which are non-arbitrable are those which must be resolved exclusively by the domestic courts of a state. It's widely been recognized that non-arbitrable matters, those which are not capable of settlement by arbitration, include criminal law matters, family law matters, corporate liquidations, and the grant of patents and trademarks. But even here there are grey areas. For example, questions of the illegality of a contract are regularly determined by arbitral tribunals, even though a consequence of the illegality may be the commission of a criminal offence. Issues concerning unfair prejudice to a minority shareholder are generally considered to be arbitrable. One topical issue that seems to us to be emerging is whether a shareholder's derivative claim is arbitrable under an arbitration agreement made between the company of which the claimant is a shareholder and a third party. Where the subject matter is not arbitrable, the tribunal does not have jurisdiction to determine it. This is perhaps why the two concepts of arbitrability and jurisdiction have sometimes been confused, but they are separate and distinct concepts, and jurisdiction issues extend well beyond issues of arbitrability. The parties to a dispute cannot confer jurisdiction on a tribunal to determine matters which are not arbitrable. That situation is to be contrasted with one where the parties consent to refer to arbitration a matter which is arbitrable. Well, that's arbitrability and jurisdiction. Let's look now at jurisdiction and admissibility. Put as simply as possible, the concept of jurisdiction in the arbitration context refers to the authority of an arbitration tribunal to determine a case, whereas admissibility refers to the appropriateness of a tribunal exercising its jurisdiction. The distinction between those two concepts has been the subject of extensive academic writings, but of less analysis in the English case law. Section 30 of the English Arbitration Act 1996, which is concerned with the competence of a tribunal to rule on its own jurisdiction, identifies three areas where the issue of the tribunal's substantive jurisdiction comes into play. It relates to issues, first, whether there's a valid arbitration agreement, second, whether the tribunal is properly constituted, and third, and perhaps most frequently arising, of what matters have been submitted to arbitration in accordance with the arbitration agreement. And as we'll see when we're looking at the Sierra Leone case in a moment, those three issues are the only ones that can be relied on in a challenge under Section 67 of the 1996 Act to any award of a tribunal as to its substantive jurisdiction. Finally, on admissibility and arbitrability, in Sierra Leone, the court equated arbitrability with the question whether there was another forum in which the claim in question should be decided. By contrast, admissibility is concerned with whether a claim that could be determined by arbitration should be so determined.
Good morning, everyone, or good afternoon, or good evening. The first of the cases that we wanted to discuss, as Stuart has already indicated, is the Sierra Leone case. Now, this was a case concerning a large-scale mining license granted by the Republic of Sierra Leone in favour of SL Mining Limited. And in particular, it concerned the suspension and the subsequent cancellation of that licence by the Sierra Leone government. Now, the licence contained an arbitration agreement for disputes to be determined by a panel of 3 arbitrators acting in accordance with ICC rules. And the key provisions of the arbitration agreement, quite common in the context of dispute resolution clauses, contain the following provisions. First of all, the parties shall in good faith endeavour to reach an amicable settlement of all differences of opinions or disputes which may arise between them in respect to the execution, performance, interpretation or termination of the agreement. Secondly, it provided that in the event that the parties shall be unable to reach an amicable settlement within a period of 3 months from a written notice by one party to the other, specifying the nature of the dispute and seeking an amicable settlement, either party may submit the matter to the exclusive jurisdiction of a board of 3 arbitrators appointed and operating in accordance with the ICC rules. So this arbitration agreement, on one reading at least, provided for a conditioned precedent to the bringing of an arbitration proceedings. First of all, service of the written notice. Secondly, good faith negotiations. And thirdly, the expiry of 3 months following that notice without agreement being reached. Now, in this case, notice of dispute was served by SL Mining on the 14th of July 2019 and was followed just 6 weeks later by a request for arbitration. SL Mining did not wait the 3-month period that was provided for by the arbitration agreement. It's not clear from the judgment why it didn't wait, but it may be because it needed to apply and did indeed apply for urgent interim relief. Following that request, the tribunal was duly formed And the SL government, Sierra Leone government, challenged the jurisdiction of the tribunal on the basis that the effect of the arbitration agreement was that no arbitration could be commenced until the expiry of 3 months. And since the arbitration had been commenced prematurely, the arbitrators were without jurisdiction. The tribunal rejected that submission, and by its partial final award, or PFA, they declared that they had jurisdiction in respect of SL Mining's claims. The government challenged the partial final award in the High Court under Section 67 of the Arbitration Act, and that challenge was heard by Sir Michael Burton. And as you'll be aware, Section 67 enables a party to apply to court to challenge an award of a tribunal, quotes, as to its substantive jurisdiction, close quotes. The term substantive jurisdiction in relation to a tribunal is defined by a combination of sections 82(1) and section 30, subsection 1 of the Arbitration Act, the latter of which was referred to in his introduction by Stuart, so as to encompass a ruling by the tribunal, A, as to whether there is a valid arbitration agreement, B, whether the tribunal is properly constituted, or C, what matters have submitted, what matters have been submitted to arbitration in accordance with the arbitration agreement. And the argument of the government focused on C on the basis that no matters had been submitted to arbitration in accordance with the arbitration agreement. And that was because the parties, the government argued, were not entitled to refer a dispute to arbitration before the expiry of the 3-month period. SL Mining submitted that this argument should be rejected for a number of reasons, the first of which is of interest for the purposes of the current discussion. It argued that the failure to wait for the expiry of the 3-month period was not a matter going to the substantive jurisdiction of the tribunal, but one going to admissibility. It submitted that since the Section 67 challenge is only concerned with absence of substantive jurisdiction, and that was not the case before the court, the application must fail. Now, the arbitration agreement was expressly governed by Sierra Leone law. However, on the Section 67 application, it was common ground that there was no material difference between Sierra Leone law and English law, and therefore the judgment proceeded on the basis of English law. And Sir Michael Burton, giving his judgment, noted at the outset that the distinction between jurisdiction and admissibility was one seemingly first drawn in the English courts in a series of 3 English court decisions between 2018 and 2020, starting with the decision in 2018 of PAO Tatneft v. Ukraine, a decision of Mr. Justice Butcher. In that case, the judge said, quote, "Issues of jurisdiction go to the existence or otherwise of a tribunal's power to adjudge the merits of a dispute. Issues of admissibility go to whether the tribunal will exercise that power in relation to the claims submitted to it," close quote. The question for Sir Michael was whether a challenge that a claim was premature is one going to substantive jurisdiction or to admissibility. The government relied on 2 English first instance court decisions, Emirates Trading Agency v. Prime Export, a 2015 case, and Tang v. Grant Thornton, a 2013 case, where there were similar temporal condition precedents and where the court accepted that the challenge was available under Section 67, substantive jurisdiction. Sir Michael declined to follow those decisions, as in each case, the availability of a challenge under Section 67 was assumed, i.e. it wasn't argued before the court, and because the cases preceded in time the distinction made by Mr. Justice Butcher, to which I've referred. So Sir Michael started his analysis of the persuasive materials in front of him with a view of the academic commentators. And he noted that the views of those commentators were all one way on the question of whether an alleged failure to comply with preconditions for referral to arbitration were matters going to admissibility rather than jurisdiction. For example, he referred to Paulson in Jurisdiction and Admissibility in Global Reflections on International Law, Commerce and Dispute Resolution, which reached the following conclusion, quotes, "To understand whether a challenge pertains to jurisdiction or admissibility, one should imagine that it succeeds. If the reason for such an outcome would be that the claim could not be brought to the particular forum seized, the issue is ordinarily one of jurisdiction and subject to further recourse. If, however, the reason would be that the claim should not be heard at all, or at least not yet, the issue is ordinarily one of admissibility, and the tribunal's decision is final." Paulson continued, "Once it is established that the parties have consented to the jurisdiction of a particular tribunal, there's a powerful policy reason to recognize its authority to dispose conclusively of other threshold issues. Those are matters of admissibility, alleged impediments to consideration of the merits of the dispute, which do not put into question the investiture of the tribunal as such." One can see, therefore, that where there is a question on the construction of an arbitration agreement as to whether the forum to determine a particular dispute is arbitration or court proceedings, or whether it's arbitration or expert determination, then the question is one of substantive jurisdiction, and the decision of the tribunal on the question is subject to challenge under Section 67. Where, however, there is no question as to forum, and the only question is prematurity, then the challenge goes to admissibility and is not subject to challenge under Section 67. The judge also referred to a passage in Merkin and Flannery on the Arbitration Act 1996, which drew this same distinction, namely that in broad terms, if the issue concerns whether the claim has been brought too late or too early, it's more likely to go to the question of admissibility than jurisdiction. The judge also noted that that latter passage in Merkin and Flannery was specifically approved in two decisions of the Singapore Court of Appeal in BBA v BAZ 2020 and BTN v BTP also 2020. More on those cases shortly. Following his survey of academic writers, which as noted, he said went all one way, and of decisions in Singapore and the US, which he considered also pointed all one way, the judge concluded as follows. He says, "The international authorities are plainly overwhelmingly in support of a case that a challenge such as the present does not go to jurisdiction. But at the end of the day, the matter comes down at English law to an issue as to whether the question of prematurity falls within Section 30 subsection 1, subsection C of the Arbitration Act 1996, which provides for the tribunal to rule on its substantive jurisdiction as to, quotes, what matters have been submitted to arbitration in accordance with the arbitration agreement." And the judge said that he didn't accept the argument for the government that much depends upon the precise wording of the clause. He said, "I do not see that there would be any difference between no arbitration shall be brought unless X as one clause and as another clause, in the event of X, the parties may arbitrate. As the government submitted," he said, "sections 31A and B give binary choice, and on the face of it, a subsection C, which I've just quoted, does not. That section could have said whether or not the matters have been submitted to arbitration, which might have given more support for the binary choice argument, but that's not what the clause says. It says what matters have been submitted." And the judge then went on to say that in accord with the views of Paulson as approved in the Singapore Court of Appeal, if the issue relates to whether a claim could not be brought to arbitration, the issue is ordinarily one of jurisdiction and subject to further recourse under Section 67. Whereas if it relates to whether a claim should not be heard by the arbitrators at all, or at least not yet, the issue is ordinarily one of admissibility, the tribunal decision is final, and Section 31C does not apply. And he noted that the short passage in the Singapore Court of Appeal is useful, which said jurisdiction, and so susceptibility to a Section 67 challenge, is commonly defined to refer to the power of the tribunal to hear a case, whereas admissibility refers to whether it is appropriate for the tribunal to hear it. And he says, in my judgment, the issue here is not whether the claim is arbitrable or whether there is another forum rather than the arbitration to which it should be decided, but whether it has been presented too early. That, he said, is best decided by the arbitrators. And for good measure, Sir Michael also drew further support from Fiona Trust and Primaloff and the observations of Lord Hoffman for the view that arbitrators are in the best position to decide whether the conditions precedent have been satisfied. And so therefore, for that reason, amongst others, he dismissed the Section 67 challenge. Just before leaving this case, and by way of a side note, it's worth noting how an English court would deal with a substantive claim that has been issued before the court for determination in circumstances where the party's contract provides for a dispute resolution process as a condition precedent to the commencement of the proceedings, and where this process has not been followed. Can the claim be struck out in such circumstances? Well, as Sir Michael noted, cases such as Cable and Wireless and IBM, a 2002 case, the court's approach is not to strike out the claim, but to simply adjourn it or stay the proceedings to allow the dispute resolution process to be followed.
We thought it would be worth looking next at the position under FIDIC contracts, and then looking at the position in Singapore. And so I'm going to take them in that order. Starting with FIDIC, one area where conditions precedent to arbitration are often found is construction contracts. And that applies both to the FIDIC 1999 forms of contract and to the 2017 ones. And they contain conditions precedent to the commencement of arbitration that include mandatory time bar clauses. Non-compliance with these clauses has been considered by arbitral tribunals in a number of recent cases, and they're reported in the ICC Dispute Resolution Bulletin. The upshot of them is that much depends on the location of the seat of the arbitration. For example, in a case reported in the ICC Dispute Resolution Bulletin 2015, an arbitral tribunal with a Paris seat found that a failure to comply with the dispute resolution provisions of the contract gave rise to an issue of admissibility, not to one of jurisdiction. It referred to the existence of some disagreement on the subject of jurisdiction versus admissibility, the fault line that Stuart was discussing. But it held that it was bound to follow French law, as the arbitration had its seat in Paris, and that under French law, this type of challenge was one of admissibility and described as recevabilité. Interestingly, the tribunal also held that there was no evidence the parties' consent to arbitration was conditional on the pre-arbitral procedures being undertaken. And it therefore didn't affect the jurisdiction or authority of the arbitral tribunal. And it seems to us that's an interesting way of looking at the effect of non-compliance with conditions precedent to arbitration. We can certainly see that if you ask whether the party's choice of arbitration as opposed to another form of dispute resolution was conditional on a time bar clause being complied with, well, then the answer is usually no. There are numerous reasons to choose arbitration, from confidentiality to speed to control over procedure and appeals. It may well be the case that the parties would choose arbitration over litigation in the courts, even if the conditions precedent aren't complied with. And it's then a short step to say the parties have impliedly chosen the arbitrators as the tribunal to decide on the consequences of non-compliance with time bar clauses. And in that case, the arbitrators have jurisdiction. It's just the claim they're faced with might be premature. However, we're not entirely sure that this is the right question. It's not so much an issue of whether the parties' consent to arbitration per se was conditional, but whether their consent to arbitration at that time was conditional. If it was, and the parties haven't waived that condition precedent, then can the arbitrators hold that they nonetheless have jurisdiction at that time? Well, so much for a Paris-seated arbitration. By contrast, tribunals with their seat in London have been more inclined to find that non-compliance with a condition precedent prevents the tribunal having jurisdiction at all. Although it should be noted that these decisions predate the Sierra Leone case that Alan was describing, so might have been determined differently if they'd been decided in 2021. But they include failures to submit a dispute to an engineer in accordance with the FIDIC contract, or to refer it to the Dispute Adjudication Board. Turning to Singapore, and not for the first time, the Singapore courts have stolen a march on the English courts in the field of today's webinar. Singapore has recognized this distinction between admissibility and jurisdiction for longer than the English courts. It precedes the 2018 to 2020 run of cases that Alan mentioned. And indeed, in the Sierra Leone case, the court relied in part on two decisions of the Singapore Court of Appeal, which Alan's touched on, the BBA case and the BTN case. And it relied on those cases in support of the conclusion that alleged prematurity was a matter of admissibility, not one of jurisdiction. Before looking at those cases, we'd like to ask for your views and your instinctive reactions by way of poll on whether certain types of objection, i.e. the ones the Singapore court was concerned with, related to an issue of arbitrability or admissibility or jurisdiction, or potentially more than one. And what we propose to do is describe the objection and then ask for your views. So you hopefully should see on the screen the first poll. This concerned an objection to an award concerning a fraud claim. It was referred to arbitration, but said to be out of time under the limitation periods under the governing law of the contract. So the question is an objection that a claim is referred to arbitration when it's become time barred an objection on the grounds of arbitrability, admissibility, jurisdiction, or more than one? Just out of interest, this was a claim where the governing law was Indian, although similar to the English Limitation Act provisions. And what the appellant was arguing was that time-barred claims are outside the scope of claims that may be submitted to jurisdiction, and hence it raised a jurisdiction issue. So admissibility. Yes, well, for what it's worth, I think I agree with you. Can we run then a second poll, which rather changes the facts in one respect, see whether this makes a difference? What do you think about this one? And this is a change that the Singapore court itself identified in its judgment in BBA. So the second poll, if it comes up on your screen, concerns a situation where the arbitration clause included some specific wording. The words were, the tribunal shall have no jurisdiction to hear claims that are time barred under statute. So if you're faced with an arbitration clause including those words, would the objection, the same one, that if the claim is referred to arbitration when it's become time barred, would that still be an objection on the grounds of admissibility, as the majority said in the answer to the last one, or arbitrability, or jurisdiction, or more than one? So as I say, this is the Singapore court discussing what difference that might make. Yes, 56% of you go for jurisdiction. And again, for what it's worth, I agree. And perhaps more importantly, the Singapore Court of Appeal also agrees. Thank you very much for that. Well, these are facts taken from the BBA decision. As I've mentioned, the English court in the Sierra Leone case quoted part of that, and in turn approving the position in an earlier Singapore decision, Swissborough Diamond Mines. That decision talked of jurisdiction being commonly defined to refer to the power of the tribunal to hear a case, whereas admissibility refers to whether it's appropriate for the tribunal to hear it. And the same case referred to another way of looking at the issue, describing jurisdiction as a concept that deals with the existence of the adjudicative power, admissibility as a concept dealing with the exercise of that power. Although it went on to then talk about not only a concept dealing with the exercise of the power, but also the suitability of the claim brought pursuant to that power for adjudication. And that idea of the suitability of the claim is, I suggest, dangerously close to the idea of arbitrability, suitability of the claim. We're getting back to the three-dimensional chess game that Stuart mentioned at the outset. And that may be why the Singapore Court of Appeal in fact said that the test that it proposed to apply was a simpler one of simply tribunal versus claim, in the sense that it's a test that asks whether the objection is targeted at the tribunal or the claim itself. Is the argument that the claim shouldn't be arbitrated due to a defect in or omission to consent to arbitration, or is the argument that the claim itself is defective and it shouldn't be raised at all? And the rationale for this test, says the Singapore Court of Appeal, is that arbitration is a consensual process. And if an objection targets the tribunal, it will mean that there is no consent to that forum. Hence, the objection is jurisdictional. But on the other hand, if it targets the claim, then it doesn't necessarily follow there's no consent to arbitration per se. It rather is an argument that the particular claim shouldn't be heard, or at least not yet. And in the BBA case, the Singapore court found that an objection that the claim was time barred was an objection that targeted the claim. So that's the first poll that we looked at, and therefore wasn't concerned with jurisdiction. But turning to the second poll, as I mentioned, the court itself said the parties could alter this. If they included an express provision in the arbitration clause, as the one we discussed, the tribunal shall have no jurisdiction to hear claims that are time barred. Absent this, it wasn't a claim that could found a jurisdiction challenge. Can I get your reaction to a third set of facts, which is a rather different set taken from the BTN case, the second one that the court discussed and relied on in Sierra Leone? And so if the third poll comes up, this is a situation where the arbitrators determined an arbitration not on substantive grounds, but by, said the appellant, wrongly applying res judicata principles. And they held that the parties were bound by an earlier decision of the Malaysian Industrial Court. So is an objection that a claim was determined by wrongly applying res judicata principles an objection on the grounds of arbitrability, admissibility, jurisdiction, or more than one? And just out of interest, the way the appellant put its case was that what the tribunal had done was bar itself from dealing with substantive issues by finding res judicata. And hence it argued that there was a jurisdiction issue here. So the tribunal had barred itself from dealing with the substantive issues because it had found res judicata applied. So I'd be interested in your reactions there. And again, majority in favor of admissibility. Yes, well, I suspect that is right. And again, similarly, the Singapore court held that was right. In the BTN case, the Singapore court held res judicata, that is a matter that targets the claim, not the tribunal, and so gives rise to an objection of admissibility. And as Alan mentioned, both of these decisions approved the approach that he mentioned in Paulson, including a quotation that tribunals' decisions on objections regarding preconditions to arbitration are matters of admissibility. He gives some examples which are quite useful, I think. Time limits, the ones we've been discussing. Also conciliation provisions before arbitration may be pursued, that's the Sierra Leone case. Mootness and ripeness, these are all matters of admissibility rather than jurisdiction. And this is because they don't amount to attacks on the tribunal or the forum as having the parties consent as a decision maker. And for Poulsen, that's key. The nub of the classification problem, he says, is whether the success of the objection necessarily negates consent to the forum. So if I pause there.
These matters have very recently come before the Court of First Instance in Hong Kong in a case called CVD, a judgment delivered on the 24th of May of this year. And I'm grateful to Louis Flannery for bringing this case to my attention. There, Mr. Justice Lamb was concerned with a challenge to a partial award on the basis of non-compliance with contractual provisions, in that case, clause 14.3 of the contract, that mandated certain written notices and attempts to negotiate before any request for arbitration. The relevant legislation incorporated Article 34 of the Anti-Trial Model Law, thus only allowing the court to set aside an award on limited grounds that included lack of jurisdiction, but importantly, not admissibility. The arbitration agreement provided for a dispute resolution process to be followed over a period of 60 days, and in default of resolution by the end of this period, either party could refer the dispute to arbitration. The challenge to the partial final award was on the basis that this period for negotiation had not even started by the time of the request for arbitration. And it was common ground in that case that the requirement for expiry of this period of negotiation was a condition precedent to any reference to arbitration. And the court held that the non-compliance in that case did indeed go to admissibility rather than jurisdiction. In doing so, it dealt head-on with one of the more powerful points in favour of a jurisdiction analysis to these cases, namely party autonomy. The court was not persuaded by the argument that the arbitration is based on the parties' consent, and if there was no contract to go to arbitration at all, an arbitrator's award can have no validity. The claimant had submitted that it was common ground that there was a condition precedent to referral to arbitration, and that before the occurrence of the condition precedent, there was no duty on either party to render the performance promised by him. The court, in rejecting this argument, which centred on clause 14.3 of the relevant contract, said the following: with respect, these observations do not address the real issue. Treating a procedural condition precedent as a matter of admissibility of the claim rather than the jurisdiction of the tribunal does not deny contractual force to the requirement. Company D does not dispute that clause 14.3 imposes a condition precedent which is enforceable and binding, nor does it contend that it should be allowed to arbitrate even if the condition precedent is not fulfilled. Rather, the crux is whether the question should be left to be decided by the arbitral tribunal, including what the condition precedent means as a matter of construction, whether it has been satisfied on the facts, without any de novo assessment by the court. And the judge said that the fact that a condition is regarded as going to admissibility rather than jurisdiction does not mean it is unimportant. What it does mean is that the arbitral tribunal has jurisdiction and may deal with the question as it sees fit. If it comes to the view that the earlier stages in a multi-tier dispute resolution clause have not been fulfilled, it can give effect to the contractual requirement by, for example, ordering a stay of the arbitral proceedings in whole or in part, pending compliance with the clause, or imposing cost sanctions, or even dismissing the claim outright as inadmissible. This approach, the judge said, has considerable advantages, for these clauses can be complex in their operation, and the arbitral tribunal chosen by the parties' agreed mechanism will usually be well placed to consider and determine what needs to be done, having regard to commercial realities and practicalities, including whether it will be futile to compel the parties to go through the motions. So the approach taken by the judge has a nuance which we didn't see in the other cases, which is to consider the argument, well, if it's all about admissibility and the claim is admitted, then the clause is essentially being given no effect at all. And the judge is saying, no, that's not the case. The clause is not unimportant. And the tribunal has a range of mechanisms for taking account of the failure to comply. And one of those mechanisms which he referred to was adjourning the claim in whole or in part, or staying it in whole or in part. And that is, I suggest, an analogous situation to that discussed earlier by Sir Michael Burton in relation to substantive claims in English court proceedings where condition precedents to commencement have not been satisfied, and where the court may, as a result, stay the proceedings for a period of time.
Well, as the BBA case shows, this does all still leave room for the type of case where the parties specify that a particular condition precedent is a jurisdictional requirement, and breach of it prevents a tribunal having jurisdiction at all. But it's clear the parties would have to use clear and express words to achieve that result. As we've seen, the tide of commentators and authorities worldwide is that non-compliance with contractual preconditions to arbitration are matters of admissibility, not jurisdiction. And we think the Sierra Leone case will have a big impact in other pro-arbitration jurisdictions. We cited in the Hong Kong decision in C versus D that Alan mentioned. We think it'll resonate in Singapore, not least because of its reliance on the earlier Singapore judgments. And although England isn't a model law jurisdiction, Singapore is, and the commercial court's reliance on the Singapore judgments means that it is, in our view, a significant judgment for other model law jurisdictions.
Sorry, I just muted myself. Let's just try and pull all these strings together and ask ourselves why the differences between the concepts of arbitrability, admissibility, and jurisdiction that we've been discussing actually matter, because there's no point debating these in the abstract from a practitioner's viewpoint. We'd like to suggest 6 reasons why in practice it matters. First of all, generally speaking, the differences matter because they delineate when the court and not the arbitral tribunal must act in the case of arbitrability, when the court may intervene in the case of jurisdiction, and when only the arbitral tribunal may act in the case of admissibility. Second, thus in the English context, the court will intervene where an arbitral tribunal purports to exercise jurisdiction to deal with a matter which is not arbitrable, and there's greater scope for a challenge to an arbitral award on the ground of lack of substantive jurisdiction under Section 67 of the Arbitration Act 1996 than there is for a challenge on the ground of a matter having been inadmissible but wrongly included, or else having been admissible but wrongly excluded before the tribunal. In that latter situation, any challenge would have to be brought under Section 68 of the Act on the ground of serious irregularity and would, except in exceptional circumstances, be unlikely to succeed. And I should just say that the whole issue of challenges under Section 67, 68 and 69 of the Act may be the subject of another of our breakfast briefings after the summer break. Third point, issues of arbitrability are not susceptible to party agreement. They're matters of public policy or public interest. Fourth, a tribunal's decision on lack of jurisdiction is conclusive on the issue, subject, of course, to any review by the supervising court. On the other hand, a tribunal's decision that a matter is inadmissible does not automatically mean that the tribunal cannot subsequently determine the claim in question. In that situation, the tribunal is not deprived of jurisdiction and, as we've seen, may in an appropriate case exercise that jurisdiction by granting a stay of the arbitral proceedings until the inadmissible aspects of the claim, such as failure to comply with prerequisites, have been addressed. Where one tribunal rejects a claim rather than dismissed it on the grounds of inadmissibility, it's open to the parties to the dispute to seek to have it determined by a different tribunal once the objection to inadmissibility has ceased to exist. Fifth, jurisdiction issues may be shared between the arbitral tribunal and the court, whereas arbitrability and admissibility issues may not be, other than in the event of a challenge to an award. One example concerns interim relief, where the power to grant it may, generally speaking, be exercised by the court or the tribunal. And finally, admissibility issues are many and varied, whereas arbitrability and jurisdiction issues, once properly identified and characterized as such, are much narrower. For example, admissibility issues include such matters as the failure to comply with preconditions to the right to arbitrate, claims being brought too early or too late, res judicata issues, and the right to seek particular relief.
Finally, we want to mention briefly, because of its rarity value, a 2021 decision in England called Armada Ship Management against Schiste Oil and Gas Nigeria Limited. And this was a case under Section 32 of the 1996 Act. As I mentioned, it's a rarely used provision. It permits the court to determine as a preliminary issue any question as to the substantive jurisdiction of the tribunal. And that's on the application of a party to the arbitration proceedings. Now, the section's rarely invoked because jurisdictional issues are normally resolved either by the tribunal itself or by the court by other means, most notably in England, a challenge under Section 67 of the 1996 Act. But the section is useful in situations where there's a lack of clarity about the scope of the arbitration agreement, or it's inherently contradictory, as was the case in Armada Ship. And under Section 32.2, the application is either made with the written consent of the other parties, or you need the permission of the tribunal, and you need to persuade the court that to determine the question will lead to substantial savings in cost. There's good reason why the matter should be decided by the court, and the application was made without delay. So this is all about dealing with it as a preliminary issue. And what I'll do, if I may, is outline the facts of the case, and then again ask for your views on whether the issue they raised was one of substantive jurisdiction, i.e. the scope of Section 32, or something else. The dispute arose under a time charter party between Armada and Schiste and concerned unpaid invoices. And the arbitration agreement provided for the arbitration to be conducted in accordance with the London Maritime Arbitration Association terms, but also in accordance with the UNCITRAL terms, although a typo in UNCITRAL, and both of those terms current at the time when the arbitration proceedings commenced. But that gave rise to problem number one, because those two terms, the LMAA terms and the UNCITRAL terms, conflicted as regards the process for appointing an arbitrator. And problem number two was that the agreement envisaged a decision by a sole arbitrator. There was some reference to 3 arbitrators, but it was tolerably clear the intention was for there to be one, but was unclear as to how they were to be appointed. And so the issue that came before the court was whether the sole arbitrator appointed by the LMAA president was validly appointed on the proper construction of the arbitration agreement. And notably, it wasn't just the claimant who wanted the issue determined as a preliminary issue. The arbitrator did as well. The defendant took no part in this at all, certainly didn't object to having this run as a preliminary issue. So if we put up the last poll, is an issue of whether the arbitrator was appointed in accordance with the proper construction of the arbitration agreement, is that an issue of arbitrability, admissibility, jurisdiction, or more than one? And I should tell you, just in case you're thinking this is all too easy, the court refused the application. I'm going to leave it to you to decide whether it was because the issue that was raised wasn't one of the tribunal's substantive jurisdiction. So the question was, is the arbitrator appointed in accordance with the proper construction of the arbitration agreement? What does that give rise to? And I'd be interested in any results and your thoughts on that. Jurisdiction, say 80%. Well, yes, absolutely right. And I think the commercial court, as I've said, refused the application. But I'll tell you that the ground on which it did so was that because Schiste had chosen to take no part in the arbitral tribunals, it shouldn't be deprived of separate protection that's afforded to a non-participating party under Section 72. So it had nothing to do with the fact that the issue raised didn't go to substantive jurisdiction. And indeed, although the court said it wasn't going to actually determine the point, it did give a non-binding indication of what the position would have been. And it said that it would have granted the application. So obviously for our purposes, the takeaway is that seeking a declaration as to the validity of an arbitrator's appointment as a matter of the proper construction of the arbitration agreement, that is an issue that goes to jurisdiction. And the court described it as a question of law, but fairly obviously it goes to whether the tribunal had been properly constituted. Now, I can briefly come on to Section 72, which, as I mentioned, was the actual reason why the tribunal declined to grant a declaration on the application. And I'll do that, as I say, pretty briefly. It's described in the cases as giving an important right to non-participating parties. It allows parties who take no part in proceedings, nonetheless, to come to court and challenge substantive jurisdiction. And the reason why the court in Armada declined to actually rule on the application was that if the Section 32 application happened in the absence of a party, but nonetheless determined the jurisdiction issue, that, it felt, would be in conflict with the party's right to take no part in the proceedings and still contest jurisdiction. Section 72, as the court put it, shows a person has a right, in inverted commas, not to engage in arbitration proceedings. And of course, that runs the risk of an enforceable reward, but that's the party's choice. If Section 32 were used in the absence of the defendant, it would result in a ruling on jurisdiction, which would bind the defendant and thereby remove much of the use of Section 32. Now, I'm going to pause there. Stuart.
Yes, I think that, ladies and gentlemen, brings us really to the end of today's talk. We hope you found it useful, as indeed we hope you found all the previous 5 briefings useful. And if there are any questions that you have arising out of today's talk, or you'd like detailed citations of the cases to which we've referred, feel free to email any of us directly. We'll be very happy to help. We welcome any thoughts and comments you may have and any suggestions for further briefings. I've already mentioned a possible briefing on challenges to arbitral awards, and we propose to have a follow-up briefing on the outcome of the Privy Council's decision in the STC and Betamax case, which we addressed as our first of our briefings before the Privy Council hearing in that case. As I said, we hope to resume the briefings in October. Please do leave your feedback on the post-webinar questionnaire that will appear in your browser after this session. And finally, the recording of this briefing will be available to view on our YouTube channel later on this week in case you missed any of the session. In order to find that channel, just type Wilberforce Chambers into the YouTube search bar, and our previous breakfast briefings are also available to view there. So it only remains, I think, for me to wish you all a good summer break on behalf of Alan, Tom and myself, and we look forward to seeing you again after the summer break in October time. Thank you very much.
Thank you all.